Okay, stop or arrest. Let me back up. This is, you know, this is Hornbook law here, you know? So that's why it's not your burden. Oh, HDN testing. I love this one. This is the eye test that police officers just love. 95% of the videotapes that I reviewed where an officer is doing this little eye test, they didn't do it correctly. Pat Barone spoke at a seminar a couple of years ago where the Macomb County Sheriff was demonstrating the HDN test. And I think that that video might still be online, where he proceeds to demonstrate how simple it is to the audience and doesn't do it right. The elected sheriff can't even do the HDN test right. Get the National Highway Traffic Safety Administration's book, and it will point out to you step by step how the officer is supposed to do it. You file a motion, though, to say that the test was not proper. Oh, I'm sorry. People versus Berger says the prosecution must establish that the test was properly performed by a person who was properly qualified to do it. You file a motion and you say the test was not properly performed and the officer was not qualified to perform it. Whose burden then? The prosecution's. Your burden regarding the breath or a blood test. All right, Michigan Rule of Evidence 104A. This is so oftentimes overlooked, and I don't understand why. It's rudimentary, but it says preliminary questions concerning the admissibility of evidence shall be determined by the court. In making its determination, it is not bound by the rules of evidence except with those regarding privileges. Preliminary questions, such as the admissibility of the eye test, the admissibility of the breath test, the admissibility of the blood test. These are preliminary questions that the court decides. And 104D says that testimony by the accused does not, by testifying on a preliminary matter, become subject to cross-examination as to other issues in the case. The federal rules of evidence, the notes, which are, the rule is identical to Michigan's 104D. The limitation upon cross-examination is designed to encourage participation by the accused in the determination of preliminary matters. He may testify concerning them without exposing himself to cross-examination generally. It's designed to encourage an accused to talk about these preliminary issues, such as whether or not the confession was voluntary. We don't want the accused afraid to testify for fear that he or she will be fully cross-examined, and the federal rules point this out.